Hi, I'm Mike Kalish, the Social Security lawyer, and in this video I want to talk about step 3 of the sequential evaluation process, equaling or meeting a listing, and what that means. Okay, just a quick recap of where we're at. Remember, when Social Security evaluates a claim for disability benefits, they use something called the 5-step sequential evaluation process. And essentially, these are 5 questions that the evaluator, whether it's at the Social Security Administration or later the judge, it's going to be the same for both. This is 5 questions that the evaluator needs to answer to determine whether or not an individual is eligible for Social Security disability benefits. So to recap where we're at, step number 1, question number 1 is the claimant working? Remember, Social Security disability benefits are for benefits that are paid based on an inability to work. So if an individual is working over a certain period of time, making a certain amount of money, basically what we would consider full-time work, then it doesn't matter what medical conditions you have, you're not eligible for disability benefits. You have to not be working. All right. Assuming that the answer is no, the claimant is not working, then we go to question number 2. Question number 2 is there a medically determinable impairment? What that means is, are there medical records? Do we have objective evidence of an underlying medical problem? In other words, are there x-rays? Are there CT scans? Are there blood tests? Are there physical examinations, psychological examinations to establish the presence of an underlying medical condition? If the answer to that question is yes, we have medical records, then we go to step 3, or question number 3, and that is, does the claimant meet or equal a listing? Now, that to most people makes no sense whatsoever. We don't know what we're talking about. So I'm going to unpack that a little bit. For the lawyers out there, we can think about meeting or equaling a listing as your motion for summary judgment in a civil case. There's no dispute as to what the facts are. Everybody's agreed that these are the underlying facts, and if these are in fact the facts that exist, then there's only one legal conclusion that can be drawn, and therefore we don't need to go through the whole process of having a trial to determine what the facts are. Everybody agrees what the facts are, and the facts will point to one legal conclusion. Right? We don't need to go any further. Well, that's sort of what is analogous to this step 3 of the sequential evaluation process. I guess the easiest way for me to explain this concept to a non-attorney is you can think of this as a type of checklist. Social Security has a listings of medical conditions, and they break them down not by actual diagnosis, but by area that it's affecting. So you have a listing, for example, of a muscular skeletal system listing. There's a cardiovascular system. There's a digestive system, and they look into each of these areas and they break them down. And then they go and they look at the medical records that the claimant has, and they want to see if there is essentially a one-to-one correlation between what the listing says the degree of severity has to be and what the medical records are saying exists. So I think the best way to get this concept across is maybe to give you an example. So I'm going to look at one of the listings, one of the more common listings, and that is listing 1.04, and that is the listing for the disorders of the spine. And the elements that need to be met for a person to be found disabled under this listing are several. All right. First of all, there has to be some kind of disorder of the spine. For example, there has to be herniated disc. There has to be evidence of a degenerative disc disease. There has to be evidence maybe of facet arthritis. There has to be some sort of underlying evidence of a disorder of the spine. Additionally, that problem has to be compromising a nerve root or is compromising the spinal cord itself. So, for example, if we've got a bulging disc, then we need to have the disc pressing against an exiting nerve root in your back. All right, that's a piece of the elements. If there's a disc, but it's not impacting on just the way the disc is angled, the way the bulge is, it's not impacting on a nerve root, or it's not impacting on the spinal cord, then we're not going to make it. It's not enough. We have to have a disc bulging, for example. This is an example. You have to have a bulging disc. That bulging disc needs to be impacting either a nerve root in your back or the spinal cord itself. There has to be pain resulting from this. Sometimes I've seen cases where people will have a lot of bulging discs, but they're not in a whole heck of a lot of pain, right? So again, there has to be evidence in the records of pain as a result of this. There has to be limitation of motion of the spine. It's difficult to move the spine. The evidence has to be there for that. You have to have some atrophy. Okay, that's associated muscle weakness. You're not using your muscles because of the pain. The muscles are atrophying. Okay, they're getting smaller. They're shriveling up. If it's the lower back that's involved, then there also has to be some evidence of a positive straight leg raising test from both the sitting and the laying down positions. So that's a test, that's an examination when you go in to see your doctor. One of the things the doctors will do on a physical examination, if you're complaining about lower back pain, is something called the straight leg test. It's something the doctors are very familiar with. And they do this test, and depending on how you respond when they raise your legs, it gives them a pretty good idea as to whether or not there's a bulging disc going on. So if it's a lower back issue, we have to have evidence in the record that you have what we call a positive straight leg test from both lying down, you're lying on your back and the doctor raises your legs up, or from a sitting position, not or, and from a sitting position. So those are the elements, right? So to recap, we've got to have a herniated disc. We have to have some kind of evidence of underlying disorder. That disorder has to be resulting in a compromise of the nerve root in your back, or it's impacting the spinal cord. There has to be evidence of pain associated with this, and if it's pain in the lower back, then we've got to have this positive straight leg raising test, and that has to be done from both a sitting and a laying down position. So what the evaluator will do is they'll gather your medical records together, and they'll go through the records, and they'll look for each of these elements, and they'll say, okay, do we have evidence of a disorder? Okay, we've got some evidence here of degenerative disc disease, or we've got here's the X-ray or the MRI demonstrating the bulging disc. All right. Is there evidence? Does the MRI show that the disc is impinging on the nerve root? Yes or no? Yes, okay, we can meet that element. Is it resulting in pain? Is the claimant talking about pain throughout the medical records? Yes. And did the doctor do this positive straight leg testing from both a sitting and a laying position? Do we have that in the record? Yes, we do. So once we have all of those elements, this checklist, if you will, all the elements are met, then that will direct a finding as a matter of law that the claimant is disabled, okay? It is at this step, this is step 3, this is the first step in this 5-step sequential evaluation that a person can be found disabled and be awarded their disability benefits. You can lose at each step, all right, but you can only win in a couple of places, and this is the first one. So, now, there's also that's called equaling a listing. In other words, we match it almost word for word, like a checklist. We got it in the checkbox. We equal the listing. You can also, that's meeting the listing. That means you've met it exactly. Checkbox approach. You can also equal the listing. What that means is, okay, we may not have every single element that I just articulated in this example. Maybe we don't have the straight leg raising from laying down position. We got everything else, but we don't have that one piece of the puzzle. In that situation, a doctor may give an opinion. A medical expert, a doctor, may give an opinion to the judge or to the evaluators at Social Security that, well, we don't have an exact one-for-one correlation with each of the elements in this particular listing. However, there are some other things that the doctor has noted in the record that will sort of make up for what's missing. And essentially, what that means is, well, okay, may not meet it, exactly, each of the check boxes, but it's sufficiently equal in the degree of problems it's causing for the claimant. We call that equaling a listing. So, but if that's going to happen, if we're going to find that a listing is equaled rather than met, then the evaluator, whether it's the judge or Social Security, is going to require expert medical testimony to that effect. The judge is usually not a doctor, and so he can't make that call. He's going to have to get an expert to say, well, is it close enough, doctor? Are we there? If the doctor says, yeah, I think we are, then again, the claimant will be awarded their benefits. That's assuming, of course, that we meet the durational requirement. This problem has to have lasted 12 months, or is expected to last for 12 months, or to be terminal. So that's the first place in the process at which you win. If you meet or equal the listing and you meet the durational requirement, then you will be found disabled for purposes of the Social Security Act. In the event that this doesn't happen, in other words, they go through this process and they say, well, we just don't have enough, there's not enough to either meet or equal the listing, well, in that situation, we just proceed on with our evaluation. We go on to steps 4 and step 5 to determine whether or not an individual meets the definition of disability. So to recap, step 3, meeting or equaling a listing, is the first place in the process, this 5-step process I've been talking about, where an individual can actually win their case. As I said before, you can lose at each step, but step 3 is the first place you can actually win the thing. However, most people don't meet or equal a listing, and that's okay too. We just proceed on to steps 4 and step 5 of the 5-step sequential evaluation process. If you have any questions, I know this is kind of highly technical, but I've tried to get it across. I think using that checkbox analogy is the best that I can come up with to try to get this concept across of what Social Security is doing at this stage. If you have any questions, please feel free to give me a call. My phone number here is 714-548-3292. Again, it's 714-548-3292. Again, the website is www.thesocialsecuritylawyer.org. I'm Mike Kalish. Thank you for watching. I hope you found this useful.